Hello all, welcome back to Metis IAS. So today we'll be dealing with a very important topic from our parliamentary democracy's perspective, and this important topic is what we call as anti-defection law. Is what we call as anti-defection law. Okay. Now, before we deal with this particular topic, before we deal with this particular topic, I want you all to tell a few instances, okay, that has been happening in our parliamentary democracy very frequently. Now, what are these instances? What are these instances? Okay, now in the year 2019, okay, it was in the year 2019, and the state was Goa, and the state was Goa. Now, the Congress party had won 15 seats in the legislative assembly elections. Okay, in the year 2019, the Congress party had won 16 seats in the legislative assembly elections. Okay. Now, even though the number is very less, even though the number is very less, what is important for us to note is that after few time, after few time, out of this 15, out of this 15, 10 members from the Congress party, 10 members from the Congress party switched to the BJP, switched to the BJP. Okay. Now, now this election was held in the year 2017, and the strength of the Goa Legislative Assembly election was 14. Was how much? Sorry, it was 40, 40. Now, now out of 40, what is happening is that out of 40, what is happening is that from the BJP, the BJP won 13 seats out of 40. BJP won 13 seats. The Indian National Congress won 17 seats. Then there was a party called as Maharashtravadi Gomantak Party that won 3 seats. Independent won 3 seats. Okay. Aam Aadmi Party did not win any seats. Goa Forward Party won 3 seats. Then there was a Nationalist Congress Party that also won 1 seats. So the magic number of this election, or in order to form a government, any party should have how many seats? They should have 21. That is more than 50%, more than 50%. Now, no party had the majority. No party had the majority. Now, what happened? What happened was that the governor of Goa, rather than inviting the largest party, that is the Congress, invited BJP to form the government. And the BJP, along with its allies, MGP, GFP, had got 19. BJP had 13, and then the other two parties, the other two, like the parties had 3 each, so it became 19. And it also was able to extract the help of independents. There were 3 independents. Okay, so their number increased to greater than 20, and they were able to form the government. Now, after 2 years, what happened was that 10 MLAs from the Congress party jumped to the BJP. 10 MLAs from the Congress party jumped to the BJP. Now, this is one incident. This is one incident. Now, fast forward to another incident. Fast forward to another incident. In the year 2019, okay, in the year 2019, there were 6 BSP MLAs in Rajasthan. That is, there was an assembly election that was held in Rajasthan, and there were 6 MLAs who got elected from the seats of BSP. There is a party called as BSP, Bahujan Samajwadi Party. There were 6 MLAs elected from this party, and once the election was done, once the election was over, the 6 BSP MLAs, what they did was they jumped ship. They jumped their ship from BSP to Congress. So basically, what is happening here is the MLAs are getting elected from one particular party, and then they are jumping to another political party. They are winning from one political party, and then they are jumping to another political party. Now, what is the problem in this? The problem is very simple. When we see or when we consider the Indian elections, okay, in India, elections are generally fought not seeing the face of an individual candidate. Rather, it is mostly fought from the aspect of party to party. That is, just because a candidate is contesting from that particular party, that candidate is going to win. Okay, that is, party system is given more or highest preference in the election results rather than the individuals who are contesting. For example, if you take the first general election that was held in the year 1952, Congress got more than 350 seats. Now, why or how did Congress get 364 seats? Congress got so many seats not because the 364 candidates were very good. It got so many seats because Congress had that legacy. And the leader of Congress, Jawaharlal Nehru, had a mass popularity among the people. So it was primarily because of the party that these many candidates from the Congress party won the elections. And another stalwart, Dr. B.R. Ambedkar, who contested not from the Congress party, but from another aspect, but from outside the Congress, could not win the election, even though he was a great leader. Even though he was a great person, he could not win the election. What was the reason? The reason is that he was not contesting from the ticket of Congress. So, in India's parliamentary democracy, generally what happens is the result of the election is primarily dependent on the party that a person is contesting. Okay. Now, when a candidate contests from a party, the leaders of the party come and campaign for this particular candidate based on the history of the party, based on the past performance of the party. This contestant generally wins. And once this person is winning, as we saw in as we saw in Rajasthan and Goa, this candidate who has won from one political party slowly jumps ship to another political party. Can this be considered as a very good practice? No. And this is what we call as defection. That is, jumping from one political party to another political party is what we call as defection. And jumping in the sense, not because any normal person, a person who has won from that political party is slowly jumping to another political party. And this is what we call as defection. In order to curb this defection, in the year 1985, through the 52nd Constitutional Amendment Act, 10th schedule was inserted into the Constitution called as Anti-Defection Law or Anti-Defection Act. So what was this Anti-Defection Act? This Anti-Defection Act, it basically punishes, it basically disqualifies or punishes individual members of the parliament or the members of the legislative assemblies, individual MPs or individual MLAs who abandon their parties for personal gain, who jump from one party to another party for their personal gain. So these MPs or MLAs are disqualified from their party or from their position. This is what we call as anti-defection law. So this anti-defection law sought to prevent such political defection which may be due to reward of office or any other similar consideration. And what was its purpose? Its purpose was to bring stability to the governments by discouraging legislatures from switching parties while maintaining the democratic principle of party based representation. For this particular purpose, anti-defection law was brought in to the Indian Constitution. Now, now, there is a history behind this anti-defection law. Now, what is the history behind this anti-defection law? Now, this history goes back to the year 1967. Okay, it goes back to the year 1967. In the year 1967, there was a general election. That is, there was a Lok Sabha election that was held. Now, we have studied from our constitutional or from our post-independent history that it was in the year 1967 for the first time that Congress is losing its popularity throughout the country. There were very various reasons. Okay. Now, even though Congress formed the government in the year 1967, the strength of Congress, which was 361, in the year 1962, the strength of Congress was 361, and from 361, the strength of the Congress came down to 283. The strength of the Congress came down to 283. Okay. Now, in the same year, at that particular point of time, there were simultaneous elections that were being held. That is, the elections for the Lok Sabha and Vidhan Sabha were held together. Okay. So that is in the year 1967, Congress lost control of seven state governments. Congress lost control of seven state governments. Now, why did Congress lose seven state governments? One of the reasons was that many of the MLAs from the Congress shifted their political allegiance. That is, from Congress, they jumped to different parties. And there was one MLA from the state of Haryana by the name of Gaya Lal. Gaya Lal. Now, this Gaya Lal, on a single day in the year 1967, okay, in the year 1967, on a single day, this Haryana MLA Gayalal has had changed his party three times. That is, for three times he is switching to different parties in the year 1967, and he was an elected representative, and he was an elected MLA. Now, similarly, Congress lost seven state governments. Now, in order to overcome this issue, or in order to overcome this problem, there was an MP from Congress by the name of P. Venkata Subhaya. Okay. Now, this MP from Congress in Lok Sabha, okay, in Lok Sabha, proposed setting up of a high-level committee to make recommendations to tackle the problem of legislators changing their allegiance from one party to another party. Now, this proposal saw a fierce debate in Lok Sabha. This proposal saw a fierce debate in Lok Sabha. Opposition members accused the Congress and they suggested renaming the proposal to Save Congress. That is why this proposal was being brought. This proposal was being brought because Congress had lost seven state governments as many of their MLAs had shifted allegiances. Okay. Now, even though there was a fierce opposition from the opposition parties, okay, the Lok Sabha agreed to the setting up of a committee to examine this problem. Okay, the Home Minister of that time, YB Chavan, headed this particular committee. YB Chavan headed this particular committee. Now, now YB Chavan committee defined defection defection and also provided a definition that defection was nothing but voluntary giving up of allegiance of a political party on whose symbol a legislature was elected, okay, except when such action was the result of the decision of the party. That is, if the party wanted a representative to give up the seat or to give up or to go away from the party. Otherwise, except in this particular circumstance, if the representative gave up his or her seat, then it was considered as defection. Okay. Now, in its report, in the same report, this YB Chavan committee also noted that the lure of the office played a dominant part in the decisions of the legislatures to defect. It pointed out that out of 210, okay, that is 210 MLAs had defected to different states, to different parties in seven states. So out of this 210 defecting legislators, this committee pointed out that 116 MLAs. How much? 116 MLAs. That is more than 50% of the MLAs were given ministerial berths in the governments which they helped form by their defection. That is, for example, let us take a state X. Let us assume in this state X, Congress has won. but by a small majority. Now let us assume 10 members. Let us assume the total strength of the house in the state X is 200. Okay. Let us assume out of this 200, 105 are from Congress and 95 are from other opposition parties. Now, out of this 105, 10 members from the Congress are shifting to another party. So Congress strength reduced to 95 and other parties, opposition parties strength increases to 105. So easily the opposition parties can form the government. Okay. So this YB Chavan committee noted that out of 210 legislators who defected from Congress to other party, 116 legislators were given the berth of ministerials. That is, ministerial berth were given to 116 representatives. And this showed that they were jumping or defecting from one party to another party, not out of their own conscience, rather in order to gain political benefits. Now, to combat this, this YV Chavan committee recommended a ban on defecting legislatures from holding ministerial positions for a year, or at least until the time they got themselves re-elected. That is, let them get re-elected in the name or in the party or from the party symbol of their new party. Until then, they should not be given the ministerial one. It also suggested a small council of ministers both at the levels of the center and state. Okay, this committee was also in favor of a political parties working together to help evolve a code of conduct to effectively tackle Disruptions. Now, this committee had suggested few recommendations. Now, what was the name of this committee? YB Chauhan Committee. YB Chauhan Committee. Now, when YB Chauhan Committee gave these recommendations, what happened was there was an attempt that was made at least twice to bring laws, okay, to bring laws to find solution to these defections. The first time was in 1973 and the second time was in 1978. Now, when we say the second time 1978, this time the government was Janata government. So even the Janata government knew the problem of this defection, and even the opposition parties, apart from Congress, also had realized that yes, this is a problem. Okay, but both the times in 1973 and in 1978, it was not successful due to various reasons. Finally, in the year 1985, a third attempt was made in order to bring a law for called as Anti-Defection Law. And this time, Congress had more than 400 seats. Congress had more than 400 seats. So it was very easy for the Congress to pass this bill through both the houses. And in the year 1985, through 52nd Amendment Act, a 10th schedule was added to the Constitution of India called as Anti-Defection Law. And this is how the anti-defection law came to the forefront. Now, before continuing, let us try to understand what is this schedule. Now, schedule in simple words means the explanation of various articles or explanation of various provisions present in the Constitution. That is, for example, if we go on adding explanation to all the articles in the Constitution, then the Constitution is going to become too bulky. Already, Indian Constitution is considered as the lengthiest constitution in the world. Now, if that is the case, if the schedules are also added near the articles itself, then what happens? Then the constitution is going to become even more bulky or even more lengthier. In order to overcome this, there is a separate provision that is added after all the articles are given. And this provision is what we call as schedule. And currently we have 12 schedules in our constitution. And the 10th schedule that was added in the year 1985 was through the 52nd Amendment Act, and it was called as anti-defection laws. Okay. Now, now this is about anti-defection law. Now we have understood this anti-defection law. Now, even though we have understood this anti-defection, now there are few more things that we need to identify. That is, if there is one single MLA or MP jumping from one political party to another party, then that is the problem. But what about the group of MPs and MLAs jumping from one political party to another party? Can that be considered as defection? For example, in 2019, I gave you the example of the 6 MLAs of BSP. BSP had won 6 seats. Now all the 6 MLAs from the BSP in Rajasthan are jumping to Congress. Now, can this be considered as defection? Now, as per this anti-defection law, this law allows the group of MPs or MLAs to merge with another party without any penalty. That is, retail defection is wrong, but wholesale defection is not wrong as per this law. Okay. Now, what is wholesale defection? That is large number of representatives, MPs or MLAs, jumping from one political party to another political party is not wrong as per this particular law. Now, what is this large number of MLAs? Originally, it required one-third support. That is, for example, let us assume a party had 30 MLAs in a state. Okay. Now, out of 30, what is one-third of 30? One-third of 30 is nothing but 10. So, even if just 10 members jumped to another party, it was not considered as defection. But this provision was changed through an amendment to the anti-defection law in the year 91st in the year 2003 through the 91st Amendment Act. Okay, and what was one-third was changed to two-third. That is, currently, if you should not be disqualified under anti-defection, at least two-thirds of the total representatives from that party has to jump from one party to another party. That is, if there are 30 MLAs or MPs from one party in the house, then at least 20 MLAs or MPs from that party has to jump to another party in order to avoid defection. So this is another principle of this anti-defection law. Now, now let us assume there is an MP or MLA who is, or there are few MPs or MLAs who are jumping from one political party to another political party once they are elected. That is, they are defecting from one political party to another political party once they are elected by the people on the name of that particular party. Now there has to be somebody to find out if this leads to defection or not, right? Now, so who is the authority to decide on the disqualification of a person who has defected? So the authority is in Rajya Sabha, it will be the chairperson of Rajya Sabha, or in Legislative Council, it will be the chairperson of Legislative Council, and in Lok Sabha or in the State Legislative Assembly, it will be the Speaker. So the authority to decide on the disqualification matters with respect to anti-defection. Who will be the authority? It will be the Speaker or the chairperson in their respective houses. Now, coming back to the normal disqualification, can you recall who is the authority to find out or to rule on the matters of normal disqualification and all other matters that we discussed while discussing the chapter of Indian Parliament? There, the authority was the president in the national level or the governor at the state level on the advice of Election Commission of India. And that time we had given an exception saying that for the disqualification related to anti-defection laws, the authority will be speaker in the lower house and the chairperson in the upper house. So this is another thing that we need to remember. Now let us assume that the speaker or the chairperson or the presiding officer of the house has ruled that a person has been disqualified or not, etc. Okay. Now, can this be questioned in the court of law? Now, when this 10th schedule was inserted into the Constitution of India, this schedule said that no, the speaker's decision cannot be questioned by the court of law. However, in a landmark Quixote Holohan case of the year 1992, in a landmark Quixote Holohan case of the year 1992, the Supreme Court said that judicial review is also applicable for the decision of the speaker or chairperson. That is, any decision the speaker or the chairperson of the house takes with respect to anti-defection, it can be questioned in the court of law. That is, judicial review is applicable for these decisions. So this is also another very important aspect that we need to keep in mind with respect to anti-defection. Okay, so I hope you have understood the basic aspects of what we call as anti-defection law. Now, now, having understood what is this anti-defection law, now it is very important for us to identify when exactly this disqualification is going to happen. Or we need to identify the key provisions of disqualification during anti-defection law. Or when does this anti-defection law come into practice? This is something that we need to find out. Now, there are four provisions. There are four provisions when this anti-defection law can be applied. Now, what are these four provisions? The first provision is that when an elected member voluntarily relinquishes membership of their political party, automatic disqualification follows. Now, what is this? Let us try to analyze. Now, let us assume there is an MLA in the state, or there is an MP in the national level elected from the ticket of Congress party. Okay, elected from the ticket of Congress party. Okay, let us take the constituency. Let us take the constituency. Let us take any constituency. Okay, let us take the constituency of Wayanad. Okay, let us take the constituency of Wayanad. Okay, so there is a Wayanad constituency, and in this Wayanad constituency, let us assume or let us consider. Okay, let us consider the real example itself. Okay, now there is a Wayanad constituency in the Lok Sabha election. So there is an MP, that is member of parliament, elected from Wayanad constituency. So who is the MP from Wayanad constituency right now? Right now, it is Priyanka Gandhi. That is Priyanka Gandhi Vadra is the MP from Wayanad constituency, elected from the ticket of Indian National Congress. Now let us assume this Priyanka Gandhi, if she voluntarily, on her own interest, relinquishes, that is, gives up the membership of the political party. That is, if Priyanka Gandhi resigns from Congress party, once she is a member of parliament, if she resigns from Congress party, then automatically she will be disqualified. Now, this is another thing. If she will resign or not, that is a completely different thing. That is a completely different thing. But just for you to understand, I'm telling this. So, if an elected member voluntarily resigns or gives up the membership of their political party or the political party from which they are elected to the house, automatically they will be disqualified. So this is the first provision of disqualification. Okay, I hope you have understood. Now let us try to understand the second provision, voting against the party direction. Now now let us assume there is a very important bill that has been introduced in parliament, be in Lok Sabha or in Rajya Sabha. Okay, there is a very important bill that is introduced in Lok Sabha or Rajya Sabha, and the importance of this bill is so much that the opposition parties will issue a whip to all its members. Okay, will issue a whip. Now what is this whip? This also we have discussed when we were discussing the chapter of Indian Parliament. Okay, so the opposition party will issue whip to all its members saying that all the MPs have to be present in the house and should vote against this bill. Okay. Now, this is a direction that is given by a political party to its elected representatives. Now, let us assume one MP goes against this whip or direction given by the political party and votes for the bill. If that is the case, okay, that is C. Members face disqualification for voting or abstaining contrary to party directions without the prior permission. Even at that particular point of time, this anti-defection law can be applied. Okay. Another very important thing is the party has 15 days to condone such actions. That is, let us assume Congress party had issued a whip to all its members to vote against the bill and one MP from Congress. Let us take an example. This is only for you to understand. Okay, let us take an example. The MP by the name of Shashi Tharoor, elected from Thiruvananthapuram, from Kerala. This MP, this Shashi Tharoor, votes against the bill. Even though Congress said that they have to vote against the bill, this MP Shashi Tharoor is voting for the bill. And the party is not agreeing for what Shashi Tharoor did within 15 days. Condone means to agree, okay? And the Congress party is not agreeing to what Shashi Tharoor did. Then Shashi Tharoor can be disqualified from his position of member of parliament, okay, in the name of anti-defection, in the name of anti-defection. Okay, so this is the second criteria or the second provision. Now let us come to the third provision. So what is this third provision? Independent members joining any parties. Let us assume there is an independent member. Okay, that is there is a contestant who contested for Lok Sabha election not on any party ticket. Rather, this contestant contested on his or on her own and won the election, defeating all the other candidates contesting from different parties. And once this independent candidate wins the election, and if this independent candidate joins a political party, and and if this independent candidate wins and joins a political party after winning, then this qualification provision with respect to anti-defection can be initiated against this independent candidate. Okay, so independently elected members who subsequently join any political party trigger this qualification provision. So this is the third provision. The fourth provision. Now, this is with respect to nominated members. Now, we know that in Lok Sabha, currently there are no nominated members, but in Rajya Sabha, there are 12 nominated members. Nominated by whom? Nominated by the president on the advice of Council of Ministers. How many members? 12 members can be nominated. Okay, based on the field of art, literature, science, social services, etc. Okay, now let us assume one or any number of these nominated members. Okay, if after 6 months of their nomination, that is, let us assume today they are being nominated to Rajya Sabha, and after 6 months from today, if they are joining any political party, then they will be disqualified. But what if these nominated members, once they are nominated within 6 months, let us assume after 3 months or after 4 months, if they join any political party, will they be disqualified? No, they will not be disqualified if if the nominated members join a political party within 6 months. But after 6 months, if they join a political party, then these nominated members or nominated representatives or nominated members from the House can be disqualified. Okay, so this is the last provision with respect to anti-defection law. So I hope you have understood these four important provisions with respect to anti-defection law. The first one is if the elected member voluntarily gives up the membership of his or her political party. The second is if the elected member votes or abstains voting contrary to the direction given by the party without permission. The third one is if an independent member joins a political party, joins a political party. The fourth one is if a nominated member join a political party after 6 months of their nomination. So this after 6 months is very important. Okay, so these are the provisions when anti-defection law can be applied. And another very important thing is this anti-defection law is applicable in the central level as well as in the state level. So at both the level, this anti-defection law is applicable. Another very important thing is, can the speaker or the chairperson take the matter of anti-defection suo moto on their own? No. There has to be a complaint with respect to anti-defection against a particular member. Only then the speaker or the chairperson can take action against that particular member with respect to anti-defection laws.